documents case. We're standing by as Trump-appointed Judge Aileen Cannon is expected to hold 2 hearings where she will consider motions to dismiss the cases from co-defendant Walt Nauta, including from co-defendant Walt Nauta, a Trump aide. This comes as never-before-seen photos have been revealed from June 2022 showing Nauta moving boxes around Mar-a-Lago. Prosecutors say that Nauta moved the boxes shortly before a Trump attorney was going to look through them after getting a subpoena to turn over classified material. CNN's Evan Perez is in Fort Pierce, Florida today to watch these hearings as they develop. Evan, what do you expect to see?
Well, John, look, I mean, a lot of these motions that the defendants are making are usually handled by briefings by the lawyers. In this case, Judge Aileen Cannon is having hearings on pretty much every single motion, which is why this case is moving so slowly. Today, we're going to hear motions from Walt Nauta this morning. This is a co-defendant of the former president, still works for him. He is arguing vindictive prosecution. Trump, in his case, and the other co-defendants are going to, his lawyers are going to be in court this afternoon, and they're arguing for the suppression of evidence. Trump wants all evidence from the FBI search of Mar-a-Lago to be suppressed. He also wants testimony from his former lawyer, Evan Corcoran. He wants that kept out of this case. Now, here's the deal. What we saw with these new documents, you're seeing some of the evidence that what the prosecution says supports their case. First of all, you saw those images of Walt Nauta, according to prosecutors. This is from surveillance video. This is where he is moving boxes before Corcoran and other lawyers were doing a search of Mar-a-Lago to be able to return those documents as ordered under a lawful subpoena. What we're also seeing, John, is one of the reasons, the major reasons why Judge Beryl Howell ordered Corcoran to provide testimony. A very unusual thing, as you know. He was a lawyer for the former president, and he was claiming, of course, attorney-client privilege. But here's what she wrote as part of the reasoning for ordering that. She said, the government has proffered enough evidence that the former president was using person 18, in this case that's Evan Corcoran, as an instrument or as a front man to obstruct the government investigation or to conceal the documents, again, that he was ordered to produce. John?
All right, Evan Perez, obviously a lot of developments down there this morning. Keep us posted. Thank you very much. Kate?
And joining us right now is CNN legal analyst and former federal prosecutor Jennifer Rogers for more on this. Let's start with one of the motions that she needs to consider today, Jennifer, which is Evan spoke to that Walt Nauta, they're trying to get those charges dismissed because of vindictive prosecution. One, what would they need to show to have a case thrown out because of that? And do you think that that's going to happen?
I do not. So you've heard of selective prosecution,
Yeah.
which is the more common motion, basically saying I'm being treated differently from any other defendant like me on the facts. This is even harder to prove, right? This is saying prosecutors are active vindictively. So it basically is the defendant is exercising a right and prosecutors are trying to punish him for that. So it's very, very high burden to get over, and I don't think there's any chance he'll meet it here. I haven't even seen really what his arguments are.
Yeah, and to that point, seeing the images that were part of the evidence that was released of him carrying boxes, that kind of is that what will speak to that's
Here's why you were being prosecuted.
I was like, this speaks to
As
the case
opposed
that
to
is before.
vindictiveness.
Exactly. And we've also learned that Donald Trump is seeking to get thrown out all of the evidence gathered by the FBI searches of Mar-a-Lago. Wouldn't that be crippling to the special counsel's case if that happened?
Oh, absolutely. I mean, remember all the photos, everything that they got.
Yeah, some of it's behind you, right there. Yeah, exactly.
So that's basically an automatic argument in any search warrant case. They always challenge the warrant is really what they're doing. They're saying there was no probable cause for the warrant or there was bad faith when they got the warrant, and so you have to throw out all the fruits of the search.
We've talked through this, but so many times before,
yes,
though.
It's not
They
gonna
tried
work.
to get documents returned. They said that they reached the point of needing to get this warrant because of the resistance to returning documents, and they had evidence that the probable cause that there were still classified documents in Mar-a-Lago.
So often what happens is they'll find some sort of mistake in the warrant itself, and they'll say, oh, you know, they lied to the court and they got the warrant under false pretenses, and so it all should get thrown out. But there's a good faith exception for law enforcement. You can make a mistake in the warrant as you list out the facts that you know and so on, but as long as you're acting in good faith and it wasn't core to the search warrant, it won't won't get thrown out, and I don't expect it'll get thrown out here.
So we're going to see some of this play out today. That's why Evan is there, and he's going to be seeing this in court. The hearing today is the first before the judge since the announcement that she was delaying indefinitely the start of the trial. It had been scheduled, I believe, to begin as early as this week if they were going to move ahead. So what do all of these motions, that some of which we're just talking about, but all of that she is now considering basically individually, what does that suggest about the overall timing of this ever getting to trial?
Well, nothing good for people who want to see this trial, right? So there are all these motions outstanding because Judge Cannon has not moved them along and has not ruled on them. And some of them, honestly, like the ones you're talking about today, Kate, wouldn't even normally warrant a hearing. You would decide them on the papers because there's nothing there. And so we have others in the queue that are the same, that she really should have decided months ago on the papers. Some more complicated things like the Classified Information Procedures Act matters, which do require hearings and should have gotten going months ago, but some that really should have been dismissed.
So this is unreasonable, you think?
I do.
It's great to see you, Jennifer. Thank you for coming in.
Thanks.
John.